series called How to Do Your Best on Law School Exams. A recent insight about meta-elements from Atticus Falcon, the author of Planet Law School 2, provides direction for students in the mastery learning and how to identify and practice the exam issues in each course before you enter the exam room. This framework helps to demystify the learning of law and empowers you. Here's what Atticus said, quote, "Remember what I call the meta-elements. No matter what the subject is, it always is a matter of someone claiming that he or she has suffered a harm, that the harm was caused by someone else, both as to cause in fact and legal cause, that the someone else had a duty not to do what caused the harm, or a duty to do something that would have prevented the harm, and that the person breached the duty to act or not to act. Then you look for any possible affirmative defense. You interweave facts with the applicable rule as to whether or not each element was established. If even one element is not established, or the affirmative defense trumps even where all the elements are established, plaintiff or prosecutor loses." Close quote. The insight of this meta-framework mastery approach for beginning law school students is in realizing that almost all legal subjects exemplify this structure. They're not all completely separate and independent entities, and you can therefore begin to frame and learn almost any subject and its issues by asking a common set of 4 questions. First, what is the set of harms addressed by this subject and its different topics? Second, what is the entrenched repertoire of harm-producing acts that typically cause these varied harms? Third, what are the relevant legal duties embodied in rules, if any, that are breached by these harm-producing acts? In each instance of a claim of harm and a breach of a duty caused by a party, are there facts that prove each element of the relevant rule by a preponderance of the evidence, the civil law standard of proof, or beyond a reasonable doubt, the criminal law standard? Fourth, and lastly, are there facts that establish an affirmative defense, even if all elements of the rule are proved? Let's look at these 4 questions in detail. First, some harms shout out at you, and some don't. In criminal law, for example, death from different types of murder and manslaughter, or loss of property and larceny, or the terrible losses from the epidemic of corporate and financial fraud offenses. But in contrast, some harms do not always shout out and must be learned. In corporate law, for example, there's a type of corporate harm if a member of the board of directors of one corporation aids another corporation to compete with it. In constitutional law, harms are illustrated by the failure of the police to administer the Miranda warnings, or police squelching of a protest rooted in First Amendment rights of free speech, press, assembly, and association. In civil procedure, there may be a procedural harm if downstream communities and farmers who use a waterway for drinking water and irrigation cannot get jurisdiction over upstream polluters in another state. But happily, you don't have to learn every harm in every subject. Rather, for each subject exam, you just need to learn that slice of harms stressed by each professor in class and in her assigned materials. Second, harm-producing acts. How the harm occurred and who did it. In each topic within any subject, there is an entrenched repertoire of harm-producing acts, spelled out in the relevant cases and elsewhere. For example, recurring iconic fact examples which cause the recognized harms. Such repertoires can definitely be identified, practiced, and mastered. To illustrate, the ancient intentional torts of assault and battery have a well-etched repertoire of harms, including threats of imminent battery, actual battery, transferred intent, and so on. Breach of contract claims usually pose often repeated iconic acts that establish or fail to establish the core contract elements, including offer, acceptance, and consideration. Indeed, one experienced law professor tellingly said that causes of action were just legal labels that summarize well-known and recurring fact patterns that embody harms caused by one party against another. I call such recurring fact patterns iconic examples of one or another cause of action, crime, or defense. You can also learn this entrenched repertoire of acts in each subject from relevant hornbooks and primers. On exams, you may actually see some of these iconic fact examples, but you will definitely see similar examples invented by each professor in her exam fact patterns. Again, you don't need to know all these acts, just the slice of iconic fact examples emphasized by each professor in class and in her assigned materials. Third, harm-producing acts must breach a legal duty. In addition to learning and understanding, first, the set of harms addressed by each subject and its different topics, and second, the entrenched repertoire of iconic acts that cause the varied harms, there must also be relevant legal duties from statutory or case-based rules that are breached by these harm-producing acts. To illustrate, intentional killings breach a duty imposed by the murder statute. Negligent behavior that causes harm breach duties imposed usually by case-based negligence rules. Once again, you don't need to know all the duties detailed in each subject, just those specified in class and in assigned materials. That's a lot. You do not need to know for the exams. Indeed, if you also daily practice hypotheticals with each such set of harms, repertoire of iconic acts, legal duties, and breaches, and also mine and weekly practice each professor's old exams, you should know all, or almost all, the issues that will appear on your exams before you enter the exam room. Understand that exam facts vary endlessly, but the set of iconic issues appear and reappear. How could they not? Fourth, affirmative defenses always trump. Finally, imagine that as a prosecutor, you have proof beyond a reasonable doubt that A intentionally shot and killed B. A is still not liable for intentional murder of B if A's act causing the death of B fits within the rule of self-defense or other affirmative defense. The general point? Affirmative defenses trump. They defeat even claims of liability that are proved in any subject. In conclusion, though not taught in law school, the benefit of knowing and practicing this meta framework for mastery learning of each course, for knowing and working with the likely and recurring iconic fact patterns and resulting set of iconic issues before you enter the exam room is perfectly clear. Once again, this and all these presentations are extracted and summarized from my book, How to Do Your Best on Law School Exams. Adios, until next time.